Are we ready?
Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Williamson. If you're joining us out there in YouTube land, we're starting back over. We had a technical difficulty. It was my fault because I had bragged on how well it worked this morning, and invariably that jinxed us. But looks like we're back ready to go. So at this time, the court will call for submission the 5 case numbers ending in 42CV, 43CV, 135CV, 136CV, 137CV, In re Billy Dean, as well as the guardianships of EMD and CDD. Ms. Ratliff, are you ready to proceed?
Yes, I am.
You may.
May it please the court. I'm Lori Ratliff on behalf of the appellant and relator Billy Dean. There's a clear point when a trial court's jurisdiction ends and an appellate court's jurisdiction begins. When an appeal has been perfected and a trial court's plenary power has ended under the rules, the Court of Appeals has exclusive jurisdiction over the case or controversy to the exclusion of the trial court. In this case, the notice of appeal was filed February 13th. 4 days later, on February 17th, plenary power ended. It was 30 days from the January 16th orders. So by February 17th of this year, this court had exclusive jurisdiction over the guardianship appointment orders. The county court here, Judge
Counsel,
Clark.
what effect does the fact that we have a guardianship proceeding have on this argument that you're making?
Guardianship proceeding obviously continues. Judge Clark continues to have oversight jurisdiction on the guardianship. However, under Supreme Court authority, Croson versus Wakeham, De Ayala versus Mackey, when there's a final order in a probate proceeding and a guardianship proceeding, those are entitled to have appellate review, not trial court self-review as what happened here. Judge Clark signed those orders on June 30th, 5 months after the case was already in your court, and 5 months after plenary power had expired, and almost 2 months after I had filed Billy Dean's appellant's brief. And so we're entitled to have those January orders reviewed by this court. There's no question that those orders are final. They say that on their face. They have language of finality in the order. And they're final in the sense that they end a discrete phase of the guardianship. To allow those June 30th orders to be valid destroys this court's jurisdiction and Billy Dean's right to have appellate review of those orders. And to allow them to be valid, Judge Clark's January orders, a clear abuse of discretion, escapes appellate review. Now, Jennifer Payne and also Judge Clark filed briefs in this court trying to explain how plenary power might be extended. Now, Jennifer Payne cites a guardianship removal statute, which applies to a guardian who loses their qualifications. Well, my client is not currently a guardian, so that's not going to apply to her. And Judge Clark cites a statute that on its face relates only to guardianships where the government is serving as the guardian or a guardianship program is serving as the guardian, so not applicable here. So for those reasons, plenary power and appellate jurisdiction, the June 30th orders are void and of no effect on the appeal for the mandamus. Now, I have other reasons in the reply brief discussing why I think those orders are void, but I would only like to mention one of them here unless there are questions about the others, because I think the one that's really important is due process, because the effect of the June 30th orders, Judge Clark in effect granted an out of time sua sponte motion for new trial He conducted the trial, he considered new evidence, and he made a new decision, all without any notice to my client. We had no notice that a new trial had been granted, and we had no notice that there was going to be a new trial on my client's qualifications when they had already been found in January. I attached to my reply brief that I filed on Monday of this week the only setting notice for June 30th in Judge Clark's court. The only thing that was set was my client's motion to dismiss for lack of authority. That's the motion where we challenge the guardian's ability to file a new lawsuit while the appeal is pending. So there was no notice to us that this was going to be reconsidered. So, and certainly that raises the issue also of res judicata. If those were finally determined in January, res judicata would bar Judge Clark from rehearing those qualification findings in June. So for all those reasons and the ones that are cited in our brief, those orders are void and should be declared that way from the court. Now I'd like to turn to the appeal part, the two cause numbers involving the appeal. Billie Dean is entitled to be the guardian of her grandchildren. The statute 1104.052, which has been the law in Texas for more than 100 years, provides a statutory hierarchy for the appointment of a guardian of a minor orphan. And the top tier, the priority, is the nearest direct line ascendant, which is a grandparent. And here there was only one grandparent that applied, Billie Dean. She was found to be qualified. And under that statute, she's entitled to be the guardian of her grandchildren. That's a mandatory statute. It's been held that for more than 100 years. But what I would like to also point out is what is not the law when it comes to appointing a guardian of a minor orphan. I know you've seen in the briefs a lot of talk about best interest and best suited, and Judge Clark's 5-part test that he used at the trial. But I would ask the court to look carefully at those briefs, because there's never a single citation to a statute or a case, because best interest and best suited are not factors when you have a direct line ascendant like Billie Dean. And to impose best interest or best suited, you render that statute meaningless. Judge Clark found, I think he's muted.
Judge Stretcher, you're muted.
Does he have a question?
I thought so. Judge Stretcher, you ready?
Go ahead, John.
Can you hear me now?
Yes, sir, I can.
Okay. And you said it direct line, it's an automatic appointment. What other facts are relevant then?
The only factor that's relevant is being qualified. So as soon as a direct line applicant overcomes the qualifications to be a guardian, which she did, Judge Clark found that, then under that statute, it's a mandatory provision. A number of courts have found that. That's all she had to show, was that she was a qualified applicant.
And how do you do that? Are you just saying bloodline and that's it?
Oh no, sir. She testified to the statutory qualifications, that she has not been convicted of a crime. There's a laundry list of things that she had to testify to, and they all did. Everybody testified to their own qualifications. So if she satisfies the statutory elements to be qualified, then the statute on its face says that she's entitled to be the guardian of the person and estate of the grandchildren.
Do you think the original order was contradictory with each other? It talked about suitable and qualified, but then it went right into best interest. Don't you think the judge had an obligation to clarify it?
I think the judge had an obligation to follow the statute. I do not think he had the authority or discretion to come up with his own test about best interest and safety and the other factors that he listed in the judgment and in the findings of fact. So once Judge Clark made his finding, and he made it twice, and I think that's important to recognize, he said it on the record. So at the end of the 8-hour or so trial, he said on the record that Billy was suitable. And then a few weeks later, he drafted his own findings of fact and said it again. He said she was eligible, qualified, and not disqualified. And so I submit it's an abuse of discretion to not follow that mandatory provision. And when he appointed a subordinate applicant, the aunt. Now I'd like to turn to the argument that Jennifer has raised for the first time on appeal. Because for the first time on appeal, she's now relying on a state's code 1104.354. That's the conflicts statute. She claims that under that statute, Billy Dean has a disqualifying conflict of interest with her grandchildren. And I'd like to make 4 points on that, probably kind of quickly because I see my time is slipping away. But the first one is, it's waived. She waived that argument, and that's really her only argument on appeal. But even if you overcome the waiver, the law does not support the argument, nor do the facts. And in fact, the evidence is actually to the contrary. And I don't want to spend too much time on the waiver. I feel like that was addressed in our reply brief, but I do want to point out that Jennifer agrees with us on the pretrial waiver. Guardianship proceedings have a unique procedure. If you want to knock someone out as disqualified, you have to file a pretrial motion in limine and get a ruling. And they agreed that they did not file a motion in limine. And the cases are clear that if you don't raise a motion in limine pretrial complaining about disqualifications, you cannot raise it on appeal. The trial court waiver, I'm relying solely on TRAP 33.1. At no point did Jennifer Payne raise by objection request or motion the complaint she raises here based on a state's code 1104.354, the conflicts provision. That's another straight up waiver. And I want to point out that guardianships are no different than any other case when it comes to 33.1 preservation. And I cited 3 cases, one of which is from your court, in re guardianship of Spear. In that case, an appellant tried to raise for the first time a statutory argument under the probate code in a guardianship. And this court said it was waived because it had not been raised in the trial court. Finally, there's no request for additional findings of fact. That's straight up waiver too. Now I'd like to move ahead a little bit and talk about the law under conflicts. You can see under 1104.354, normally a guardian cannot be in a lawsuit that affects the welfare of the ward, unless there are 2 big exceptions to that rule. And the first one is if the trial court finds that there is no conflict. And the second one is if the court appoints an ad litem. Now, Jennifer cites that section many times in her brief, but she never cites the 2 exceptions. And those are what control in this case. Because by Judge Clark's finding that Billy was qualified, he necessarily found that there's no conflict and that there would be no barrier to her serving as a guardian on behalf of her grandchildren in a wrongful death lawsuit. I want to turn quickly to one of the cases that Jennifer relies on, Morales versus Alvarez. She cites it in literally every brief. That case is an old probate code, section 110. That's the old version of the conflicts provision that did not have the two exceptions. It was an absolute bar back then to being a guardian and being in a lawsuit that impacted the welfare of a ward. Given my time, I would like to go ahead and move forward a little bit, skip some of this stuff. But one thing I think is important to talk about, and that's the fact that Billie does not have an adverse or conflicting interest with her grandchildren. Her interests are completely aligned. If she were the guardian and in that wrongful death lawsuit, they have the same goal, which is to maximize recovery. There is no conflict between Billie and her grandchildren in that respect. And I'd like to point out to the court that families are in litigation like this all the time, even where there may be an allegation that a family member has some liability. That does not preclude a lawsuit from going forward and recovering. Now, I'd like to turn last to the mandamus. I see my time is quickly evaporating. The mandamus involves a really simple statutory provision, very narrow. It's probably the shortest chapter in the Guardianship Act, chapter 1152. And that chapter is entitled Guardianship Pending Appeal of Appointment. So it absolutely is what controls in this situation. And of course, when a guardianship is appealed, the guardian remains the guardian. You couldn't have a bond to get rid of them. Somebody has to serve. But there is one limit, and that's in 152.0012. And the limit is that guardian, while they're pending on appeal, can only prosecute a pending suit. It defies logic that a pending suit could mean file a new lawsuit. But I would ask the court, when you're looking at this, if you flip back to the preceding chapter 1151, that's the chapter that applies when there's no appeal. Nobody's been appealed, the guardian's in place. And you go to subchapter C and you'll see a laundry list of powers that a guardian has. They can file a lawsuit, they can settle a lawsuit, but that authority ends if their appointment is on appeal. And that's what 1152, the next chapter, is about. And in this case, when we filed the notice of appeal on February 13th, we invoked that statute. And Jennifer Payne could no longer go out and file a new lawsuit. All she could do was prosecute a pending suit, which she did. She intervened in the Harris County wrongful death case in February. But then in March, she filed a lawsuit in Ector County, March 19th. And that's the lawsuit that she had no authority to file under that statute. She could not file a new lawsuit. And then she non-suited the Harris County lawsuit in April and purports to settle the Ector County lawsuit a mere 2 months after filing it and with no discovery. So the statutory construction argument in the mandamus is very simple. The specific statute controls the general. The specific statute that applies when a guardianship appointment is on appeal controls the vast powers that you have in chapter 1151 when there's no appeal. And of course, the court knows you have to read these statutes such that all of them have meaning and that none of them are meaningless. Judge Clark and Judge Trotter abused their discretion when they refused to enforce this limitation in chapter 1152, when they've allowed Jennifer Payne's lawsuit filed without authority to continue forward. So I do want to mention one other point about the mandamus, and that's kind of a practical point. You know, we're coming in raising this issue about Jennifer Payne's authority, and nobody else is going to raise that if we don't. Jennifer Payne's not going to say, I don't have authority. The purported settling defendants are not going to say that. And the ad litem is not going to challenge her authority. So if we don't challenge it, and this court doesn't respond and limit that authority, then her actions during this interim time while her appeal is pending will never be reviewed. They escape review. She has no limit on her authority. And that's clearly not what the statute envisions. And with that, I see my time is winding down, and I will save the rest of my time for rebuttal.
Thank you very much. Mr. Kaiser. Mr. Kaiser, you're muted.
How's that? Sorry. I love technology. May it please the court. Steve Kaiser representing Jennifer Payne, the appellee, the real party in interest, counsel. Thank the court for working with us to set up this Zoom argument. It's a very important issue, and appreciate everyone's extraordinary efforts to get us all together. A guardian, of course, as the court knows, is a fiduciary required to put the children's best interests ahead of her own at all times. And the role of the court is to ensure that a guardian for minor children is capable, eligible, qualified, and most importantly, not disqualified with some sort of interest that conflicts with that of the children. And when we're deciding whether that is or is not the case, there should be no question. Of course, of paramount importance is protection of the children. Judge Clark has always had that goal in mind. His writings have made that clear. He had it in focus on January 15th, straight up to June 30th, and even today. What are the best interests of the children? And he's given huge discretion over who to choose as guardian. What I think all parties agree is that even despite this ascendancy statute, all the cases cited by the appellant and all of our cases agree that what the answer is to Judge Stretcher's question, what other factors are there? She must not be disqualified. And in addition to being grandmother, she cannot be disqualified. All the cases say she's entitled unless disqualified, and she is undeniably disqualified, not only under the evidence that was at trial, but the evidence that was considered by under the motion to dismiss. Yes, a person may not be appointed a guardian if they claim an interest adverse to those of the children, which they do. Billy and Jack, her husband, are plaintiffs in the Harris County suit. There's no question about that. No one really denies that they have their own, they're seeking their own individual recovery separate from the children. And in that sense, children and they are competing for a finite amount of recovery. Those facts alone,
Mr. Kaiser,
as a matter of law, to disqualify her, and the appellant agrees with that. In fact, has made that very argument in seeking to have Jordan Dean disqualified on those very grounds. Jordan is a plaintiff in the Harris
Mr. Kaiser
lawsuit. I'm sorry.
How do you respond to the argument? And I don't know, it's been about 20 years since I was a real lawyer. We called them friendly suits or minor prove-up settlements, where a parent had a claim and they also were the next friend of their child, and they sued a State Farm or an Allstate or a Farmers Insured. My old boss, Roger Glandon, would send me over to the courthouse and get it settled out, get the approval. The parent and the kid were on the same side of the V, so to speak, you know, Jones versus Jenkins or something like that. Is that the situation that we have here, or is it different?
It's different. And here's why. A guardian ad litem, what would happen in those cases is that guardian ad litem might be appointed, or attorney ad litem, a guardian ad litem, to represent the interests of the children in determining whether the settlement was fair. But this goes far beyond mere apportionment of settlement proceeds. And I'll tell you why. Billy Dean has a far different interest in this litigation than does the children. We've pointed this out in the supplemental briefing and the mandamus. It's not in the appellant case yet, but for one thing, in the Harris County suit, Jack Dean is alleged to have been responsible for the deaths of the children's parents. He was the supervisor of the Aghorn facility where the H2S escaped and where they were killed. He's alleged by one of the cross plaintiffs to have instructed Natalie to actually go into the building without any personal protective equipment, causing her death. Aghorn is responsible for the actions of Jack, but Billy Dean and Jack Dean have no case against Aghorn. They are barred by the workers' comp statute from suing Aghorn. So their interests are different. The children have a great lawsuit against Aghorn and need to pursue that, need to obtain findings against Aghorn. Billy has every reason to want to shift the emphasis away from Aghorn over to defendants that she can sue. And oh, by the way, she has, in order for the children to recover and have their best chance of recovering, they have to blame Jack, her husband. Now, you can't expect a guardian ad litem to take on all of that kind of responsibility. If Billy were the guardian and the ad litem has to communicate with her regarding trial strategy and at the same time sue her husband or even her, and what about trying to limit Aghorn's responsibility and their percentage of proportionate responsibility away from the other defendants? That's directly contrary to what the children would want. Should a guardian ad litem be required to make those decisions? And oh, by the way, that's not even a guardian ad litem's role under the law. If you look at Rule 173, it says that a guardian ad litem for someone who has an adverse interest, a guardian that has an adverse interest, should not participate in discovery, trial, or any other part of the litigation unless further participation is necessary to protect the party's interest that is adverse, or the participation is directed by the court by written order. But the comments then explain what that means. It says that the rule contemplates, comment 3 and comment 4, right behind Rule 173.7 say, the rule contemplates that a guardian ad litem will be appointed when a guardian appears to have an adverse interest because of division of settlement proceeds. In those situations, the responsibility of the guardian ad litem is very limited, and no reason exists for the guardian to participate in the conduct of the litigation in any other way or to review discovery or any of the litigation matters. Only in extraordinary circumstances does the rule contemplate that a guardian will have a broader role, but in no event, it says, may a guardian ad litem supervise or supplant that party's interest to represent that party serving as guardian ad litem. So a guardian ad litem does not fix this problem, and it is not at all like a friendly suit. The adversity of interest goes far deeper than merely dividing up settlement proceeds, if that answers the court's question. Because of all of that, she's clearly disqualified. 2 courts have now said that. Judge Trotter found that her motion should be denied after he denied jurisdiction and standing, said it was without merit. Judge Clark has now found, based upon a motion that Billy Dean herself filed, and I think he was entitled to make this finding, that she is disqualified. One of the justices, I believe it was Judge Bailey, asked earlier, why is it different that this is a guardianship proceeding? Well, it's because this is not a final order. It's an interlocutory, or if you read the cases carefully, they say we're going to consider these guardianship orders. A guardianship is an ongoing proceeding where there's discrete little issues that get decided along the way. And at times they need appellate review on an interlocutory basis so that that decision doesn't, you know, it's going to impact something that happens on down the line. So we're going to say that these guardianship proceedings are exceptions to the one final judgment rule, but they're not truly final. They are interlocutory but appealable orders. So to say that the trial court loses the ability to reconsider issues, how could that be? For one thing, let me point out to the court that a court on its own motion, sua sponte, a trial court on its own motion can remove, it has to be with notice, but can remove a previously appointed guardian if the court determines that for some reason he didn't realize she was disqualified at the time of the original appointment, or if she's later become disqualified. So in that sense, an order appointing a guardian or making some finding can never be and is not res judicata in the commonly understood sense of the word, because it's always changeable. And the appellant says, well, but does that make it a moving target? Yes, it makes it a moving target because it has to be. It has to be a moving target for the court to have the ability to continue to oversee and administer the guardianship and protect these children. I cite the court to the Macer case that we cited. It says everything I just said, but most importantly, it says, even though they're considered in a sense final for purposes of appeal, that consideration does not deprive the probate court of plenary power over the entire proceeding, including its prior rulings. And I also can refer the court to Appellate Rule 29.5, which I frankly don't understand completely, but it says exactly this: while an appeal of an interlocutory order is pending, the trial court retains jurisdiction of the case and may make further orders, including one dissolving the order complained of on appeal. I don't know how to read that any other way than to just read that. Of course, the court can't make an order that conflicts with a temporary order of this court or destroys this court's jurisdiction and somehow, or the effectiveness of the relief sought. But what I don't think that means that impairing the effectiveness of the relief sought means that if you change the order and you somehow impair the ability of the appellant to reverse it, then it's no can do. I don't believe that's what that means. So the court, when he made that finding, he did not change his original temporary order appointing Jennifer Dean the guardian. So he's not entered an order that was inconsistent with the original order. He's not violated a temporary order of this court. He's not impaired the jurisdiction of this court to consider whether he abused his discretion in the first place in appointing.
Counsel, that original order just seemed to be a little inconsistent because he found no disqualification, but found the best interest to be another individual. So didn't he retain the right to clarify his order?
I can see that argument. I certainly can. I frankly didn't think of that this could be considered a clarification order. Yes, he's all over the board, very, very seriously showing how he carefully considered the interests of the children and why he believed the things he believed, long and very detailed reasoning. And then quite frankly and candidly, he makes this order at the end that everybody is qualified, eligible, and not disqualified, but the best interests of the children override all of that. To the extent that that's inconsistent, I agree. He is entitled to clarify what he really meant. I can't and should not try to get into the court's mind at the time. I frankly think he was focused on something else and did not realize what this finding of disqualification what the ramifications ultimately were, which of course led to this appeal. Why is changing his finding prohibited? I don't understand why that is. The appellant.
Would, counsel, would we be, yeah, I mean, changing his finding, what if the guardian had a stroke? Or what if the guardian had a heart attack? Or could he not change guardians then?
Of course he could. And has to be able to do that. His findings on this are interlocutory, and he's got an ongoing duty to analyze qualifications. So yes, I think he clearly has the ability in an ongoing administration of a guardianship for a minor to constantly analyze. And I can't read, I don't have the rule in front of me exactly, but I can't read that removal statute rule any other way than exactly what you're saying, that even sua sponte, on the court's own motion, he could remove a guardian for a whole number of reasons, one of which, though, is disqualification. Either one that has arisen since the appointment or one he realizes existed at the time of the original appointment. So I do not think there is a due process problem with any of this, and here's why. The appellant or the relator filed this motion to dismiss. I don't have the whole title in front of me, that this court allowed not only Judge Trotter to hear, but Judge Clark to hear. And it was a very broad motion. In it, Billie Dean argues that she's the only proper guardian. She tells the court why he's messed up, emphasizing the trial court's orders. She notes her appeal and that she's going to win on appeal, and gives her appellate arguments. She challenges Jennifer Payne's authority. She actually asserts in this motion, as she has elsewhere, that, quote, the guardianship appointment orders are not final and Jennifer is merely a placeholder guardian. That's interesting in light of their argument now that they are final. She says that guardian status has not been finally determined, and that Jennifer Payne has no authority, and demands that she appear and show authority. So the gauntlet was thrown down, and Judge Clark picked it up and said, okay, I'm considering all of that, and I'm entitled to and do reconsider my early finding, and I make this judgment. Jennifer Payne is the duly appointed and current guardian. She's qualified to act as guardian. Billie Dean is disqualified to serve as guardian, and therefore Jennifer Payne has authority. There was notice of that hearing. We made it clear in our pleadings what we were requesting the court to do. I went so far as to ask the court to reevaluate that finding based on the undisputed evidence, and argued against all of the things that were raised. I think the court was well within his right. Whether you call it a clarifying order or whether it's a reconsideration now based upon the filing of this motion, it didn't violate the court's stay order. It was a natural finding based upon the motion to dismiss. And it's not an abuse of discretion to have done so. Again, this is all reviewed under an abuse of discretion standard. Court does not review these findings for factual and legal sufficiency. And again, I'm not quite smart enough to understand all of that. I know there are factors in determining whether an abuse has occurred, but the court should consider that abuse of discretion standard to review in reviewing and considering this clarification order, the June 30th order. It at least underscores the fact that the trial court did not originally abuse its discretion in appointing Jennifer Payne, that maybe, in fact, he did believe that Billie Dean was disqualified and just inadvertently or wrongly made this global finding that everybody was not disqualified. But it certainly now shows what the court believes the evidence shows. Let me turn really, really quickly to the issue. I've got a minute and a half left. I'll speak even faster than I'm speaking. I apologize. To the 520012 argument. That statute, which appellant wants to say is a standalone statute that controls everything else, just is not. First of all, it just simply does not say what Billy Dean claims. It says that pending an appeal, the guardian shall continue to act as guardian and shall prosecute a pending suit in favor of the guardianship. It does not say she may only do that or that she is prohibiting from functioning as a guardian otherwise. And no one disputes that a guardian has the right to file suit on behalf of the minor, has the power to defend suits for the minor, has the power to settle suits with court approval. None of that is disputed. And rather than reading this isolated, the specific controls, the general type of argument, courts really should read the entire act dealing with a guardian's powers and read it harmoniously. Our argument is the only one that does that. You should not construe statutes in isolation, but as a whole. You should not assign a meaning to a provision that would be inconsistent. And for example, if the guardian's only authority is to prosecute a pending appeal, how does it defend a guardian in a lawsuit that comes up? And suppose a guardian filed a lawsuit and then is removed and a successor is appointed. This statute makes it clear that pending the appeal, the successor should continue to prosecute that suit. And suppose an adult files a lawsuit and then becomes incapacitated and a guardian is appointed. That guardian is, the statute makes clear that that guardian is to continue to prosecute that suit. Those are not matters that are really addressed in any of the other statutes. So our interpretation creates harmony, theirs create conflict. And as a last thing before I sit down, I point out that Jennifer Payne literally did continue to prosecute the pending suit. The claims she made in the Harris County suit once she became guardian are identical to the claims she makes in the Ector County suit. The venue was just moved. It's a proper venue in Ector County. Since that time, she has prosecuted the wrongful death suit against the same defendants under the same theories in the Ector County District Court. And I think the court could very easily say, put aside everything else, she literally is continuing to prosecute a pending suit on behalf of the minors. Trying to think what else I need to say to you. I know. Oh, yes, let me go back and say one thing. Never until the most recent briefing has Billy ever said why she's not disqualified. Never once, other than to say Judge Clark made this finding on her behalf, not one time. Finally, she says, oh, we don't have an adverse interest because our interests are aligned because we want to maximize recovery. And I just want to point out what I said earlier, that their interests are in no way aligned. Yes, do they want to maximize recovery? Yes, but they want to apportion it a different way. They want to seek it against different people. She doesn't want to sue Jack. She has no cause of action against Aghorn. For all those reasons, their interests are not aligned. I appreciate very much the court's willingness to listen today. And thank you very much. And listen, I'll sit down.
Thank you, Mr. Kaiser. Ms. Ratliff, this is an important case. We'll, of course, give you a few extra minutes as well if you need that time.
Thank you very much. I want to start with one of the phrases that Jennifer's counsel said, and it was, somebody should have to blame Jack. Somebody should have to blame Jack Dean. I'd like to point out to the court the lawsuit that Jennifer rushed to file in Ector County. She did not sue Jack Dean. She wants to tell you how liable and culpable he is, but she did not sue Jack Dean in her lawsuit in Ector County. So I find that to be a little interesting and talking out of both sides of their mouth. If he's so liable and so culpable, then why didn't she sue him? The second point I want to make along that line about Billy having a conflict. When Jennifer Payne purported to settle the Ector County lawsuit, there are people in 6 different capacities as plaintiff. Jennifer's in it as a guardian. Jennifer is in it as a representative of her sister's estate. Jennifer's parents, Robert and Marilyn, are in it. Jordan, the half-sister, is in it individually, and Jordan is in it on behalf of her father's estate. So they're talking about a conflict on our side. The conflict is just the same on their side. They're fighting family members over the money. It's no different than an allegation they make as to our side. So I think that argument has no merit whatsoever. I want to mention at the beginning, Mr. Kaiser, again, oh, it's all about best interest. He never cites a single case for that. I thought he might get up and have one, but he doesn't. That's completely a made up standard that has no application in this case. Now, I want to talk about Billy and Jack. Billy has a claim against Aghorn, and Jack does too. They're suing Aghorn, and they're going to try to get exemplary damages from Aghorn because they can. They have a lawsuit against Aghorn. So there is no conflict there between Billy and if she were representing her grandchildren as the guardian. Now, they talk to you a lot about, well, you know, Judge Clark had this epiphany, right, on June 30th. He finally realized there was a conflict. But I would ask the court to go back carefully and read the transcript from the January trial, because 2 witnesses talked about Billy Dean being a plaintiff in the Harris County lawsuit, and maybe Jack Dean's going to be a defendant. So that's nothing new. That was put before Judge Clark in January, that there's this potential conflict. And so it's not a new thing. Judge Clark heard that testimony that Billy's a plaintiff and Jack may be a defendant, and he rejected it. He rejected it the only point in this case when he was an objective player. He has injected himself into this mandamus as an adversary. He's filed 2 briefs in this court as an adversary. So to think that he's now acting objectively, I would think is a little bit questionable. But that evidence was absolutely in the trial in January, and it was rejected. Now I want to talk a little bit about this.
Excuse me, counsel. Somebody acting objectively is questionable. Who are you talking about?
I think that Judge Clark's ruling, once he has become an advocate in the mandamus proceeding, it's a little bit tough to believe that the June finding, now reversing himself, when the evidence was in front of him in January, and he didn't find a conflict then. Now I want to talk a little bit about.
Well, wait a minute. Before we move on, I want to make sure I give you time and I understand. You're saying that there is no conflict, 0, between your client and the wards. Is that correct? The children?
That's correct. There is no conflict between the wards, between my client and the grandchildren. They would be completely aligned if they were in a wrongful death lawsuit after the same defendants. They have no conflict. And that's what Judge Clark found in January. And that seems to be getting lost in this discussion. The evidence was before him then, and he rejected it. And he was the person to resolve those inconsistencies and look at the witnesses to decide who was credible. And at that point,
Counsel, I don't think it's getting lost. I think he changed his mind, or he clarified his order. I mean,
I don't think he has the ability, once a case is on appeal, to suddenly change his mind. We're entitled to appellate review of that ruling. There is no law before you that says he just gets to keep thinking about it. I mean, when does it end? I mean, when y'all write the opinion, can he just still say, well, I'm going to make another decision? And
counsel, you know that's not right. I mean,
I don't know that. I don't know that, because I would have never thought someone would have granted a new trial, held a new trial, and taken new evidence without giving notice. I would have never thought that. But I want to go back, Justice Stretcher, to your question about does a court have authority to reassess a guardian while they're serving? And I think the answer is absolutely yes. I mean, a guardian, like you said, could become incapacitated. But that's not what's happening here. We have an applicant who's appealed a guardianship order who's being reversed. The finding is being reversed while it's on appeal. I want to mention quickly about the notion that these were interlocutory orders when they were signed in January. On their face, they're final. Under De Ayala versus Mackey, they're final. They're not interlocutory orders. Rule 29, I cited a case in the brief, has no application to a final judgment. They sought the in re guardianship of Macer. In that case, a trial court had made an interlocutory ruling on attorney's fees. Nobody appealed the order. It remained an interlocutory order within the case. And at some point later, the trial court reconsidered it and reversed it. And it went up on appeal, and the argument was, well, can you do that? And the Court of Appeals said, of course you could, because it was unappealed interlocutory order. That's not what we have here. We have a final order that was on appeal. I want to go back to this due process issue. I think that's probably the linchpin of this case, is to allow a trial court with no notice to accept new evidence without any notice to a party, no chance to participate. I think that's probably what cries out the most on why this case should be reversed. And I absolutely do dispute on the mandamus. I absolutely do dispute Jennifer's ability to file a new lawsuit. That statute is absolutely clear. She has no authority to file a new lawsuit. She could prosecute a pending lawsuit. That was it. I would ask the court to reverse and render the guardianship orders, find that Billie Dean was qualified as it was found in January. By statute, she's entitled to be the guardian. I would ask that the court on the mandamus declare that those June 30th orders are void and of no effect in the appeal and in the mandamus. Order that Jennifer Payne has no authority to file that lawsuit, and order that the district court dismiss the pending lawsuit that's in the 358th District Court.
Thank you very much. At this time, the case has been submitted, but I would ask Mr. Kaiser to join us. We realize that this is a situation where it's been fluid and that there have been quite a bit of additional briefing. I have an inquiry to make is, do the attorneys feel like there will be additional briefing submitted? And if so, would we like to set a deadline for that so that we could proceed with getting this case out, or these cases out?
I would like in the mandamus to be able to respond to the 3 responses that came in. I filed the supplemental petition July 6th or 7th, and then the court asked for responses, and responses came in, some of them this week on the 20th. I'd like to be able to reply to those in one document.
Okay, Mr. Kaiser, do you anticipate?
The only thing that we really haven't responded to is this guardian ad litem issue that I went on and on about. Unless the court feels like it fully understands my position, I think I can put that in a fairly simple letter brief. I may want to address this due process argument and Judge Stretcher's idea about this being a clarifying order. So whether that happens in which case that happens in, I'm not sure, but I'll figure that out and submit it. I may just put it in all the cases.
Well, if you wanted to do a letter and put all 5 case numbers on it, that would not be a problem with the court. These are, on some level, it's a unified proceeding.
Yes, I think so.
Because of the parties,
Great.
I would just ask to have a chance to reply to whatever he's going to file. I mean, I am the appellant. I'm the appellant.
You could just tell us you've heard enough.
Yeah, I might be opening Pandora's box.
Enough briefing.
Okay, my thought would be, if you could get that your initial filings to us a week, 10 days, something like that. We do have a keen interest on getting an answer on these matters out. so that these kids can be taken care of appropriately.
I'm fine
With
with
that
the
being-
10 with 10 days to get the first round in.
Okay. Is that okay with you, Mr. Kaiser?
Absolutely.
Okay. All right.
And I
Let's
can
do that.
respond-
And then you could indicate, if you felt like I need to respond to something that the other one filed, hey, it's on its way. And that way we'll know to be watching for it.
Sounds
If
great.
that's okay. All right. All right, Miss, your case has been submitted. Miss Williamson has now joined us and she will be adjourning us.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.
Thank you very much.
Everyone stay safe.
Yes, sir. Thank you.
Thank you.